Buckley versus Valeo is the most important campaign finance case ever decided by the Supreme Court. Every subsequent case, and every legislative attempt at reform, operates under the framework established in Buckley. Buckley considered the constitutionality of the Federal Election Campaign Act, FECA, which imposed several restrictions on the financing of federal campaigns, including restrictions on both how campaigns could acquire money and how campaigns and others could spend money in promoting the election or defeat of federal candidates. The First Amendment protects Americans' rights to free speech and free press. When someone wants to reach an audience with speech, that person has to expend resources in order to develop the speech and in order to distribute the speech to a potential audience. FECA did not directly tell people that they couldn't speak, but it did tell them that they couldn't raise a certain amount of money, and it told them that they couldn't spend a certain amount of money in certain ways. Therefore, it interfered with the ability of people to collect money and spend that money in producing and distributing speech. Therefore, Senator Buckley and the others who challenged the law said that FECA interfered with their First Amendment rights because it made it much more difficult for them to make speech and deliver it to an audience. The key question in Buckley versus Valeo was the extent to which the First Amendment prohibits the government from interfering with campaign financing. As the court decided Buckley versus Valeo, it turned out that the answer to that question was quite complex. Although the First Amendment was implicated by campaign finance restrictions, the First Amendment was not violated by all of them. Rather, the court concluded that there was a very important interest in eliminating corruption or the appearance of corruption, and that limitations on contributions could be necessary to serve that end. However, the court concluded that the federal law's restrictions on campaign expenditures, a much more direct limitation on speech, were unconstitutional because of the interference that they placed on First Amendment rights. Having concluded that expenditure limits present such a manifest threat to core political expression, the court struck down the limits that FECA placed on individuals' ability to spend money independently of the candidates. The court also struck down limits on the expenditures that could be made by the campaigns and by the candidates themselves. The court upheld, however, FECA's restrictions on contributions, as well as its requirements that donors and some speakers disclose their identities so that the public could learn who was supporting each candidate. The contribution limits, the court reasoned, were closely related to the government's compelling interest in minimizing corruption or the appearance of corruption. By corruption, the court meant a quid pro quo, the exchange of a contribution for favorable treatment by the candidate once in office. Limiting contributions to $1,000 per election, the limit has since been raised and is now $2,800, meant that no donor could give so much money that the office holder would be beholden to the contributor. In sum, the court made three conclusions. Number one, restrictions on campaign financing do trigger First Amendment protection. Number two, despite that, limits on campaign contributions are constitutional because they are designed to limit corruption or the appearance of corruption. And three, restrictions on the expenditure of money by campaigns themselves or by individuals independent of the campaigns are unconstitutional because they present a direct infringement on free speech rights. Buckley and its distinction between contributions and expenditures continue to shape our campaign finance law and our understanding of the ways that the Constitution's protection of free speech applies to campaign financing.